guys to give me a second chance to live and to tell you guys who I really want to be.
He's a man. He's a son. He's a father. He's not the one who killed these individuals.
Zachariah Craft, a 24-year-old man, made a dramatic scene during his initial court appearance after being arrested for punching and kicking 2 Belgrade police officers. Clearly agitated, he shouted angrily in the courtroom, expressing his disagreement with the charges against him.
Take me off the what you guys were doing to me! I have a broken hand!
This was not his first run-in with the law. Court records indicate that Craft has been jailed 7 times over the past few years. His outburst escalated quickly, prompting law enforcement officers to wrestle him to the ground and remove him from the courtroom. He was then placed in an isolated holding cell to prevent further disruptions. On June 23, 2013, Judge Timothy Corrigan was the target of an assassination attempt by Aaron Marcus Richardson. Timothy survived because the bullet missed his head by only 1.6 inches. At the time, Timothy and his wife had just returned from a wedding and were relaxing at home. He was sitting in his favorite chair with his wife just 5 feet away. Suddenly, he heard an incredibly loud explosion right by his right ear.
You look through. He's looking through because the judge is leaning back, and you can imagine the judge's head is here. And he saw, without a doubt, he had in his heart the intent to.
His wife quickly dropped to the floor, shouting for Timothy to join her because there was a firing. Still somewhat disoriented, Timothy eventually got down and crawled out of the living room. They were able to call the police, who arrived soon after. But by then, Marcus, the assailant, had already fled.
Through the scope, he only saw the judge's head, but the muzzle of the weapon, magic.
2 days later, the police caught Marcus, although he tried to mislead them with false statements. It was revealed that his reason for targeting Timothy's head was a 2008 case in which Corrigan had sentenced Richardson for attempting to make a bomb.
I think he attempted to kill the judge so that the judge could not disavow having authored that order.
Richardson came up with a plan he called Mission Freedom, which involved forging an order that appeared to be signed by Judge Corrigan, aiming to dismiss all his pending charges and even get his driver's license and credit back. In the end, Richardson faced a long list of charges, including attempted murder of a U.S. district judge, discharging a firearm during a violent crime, stealing a gun from a dealer, possession of a firearm as a convicted felon, possession of a stolen firearm, impersonating a police officer, 5 counts of making false statements to an FBI agent, and 9 counts of lying to a probation officer. Richardson was sentenced to 343 years in prison. In July 2021, Dominic Aguilar Acevedo tragically lost his life in San Antonio, Texas. His mother, Nicole Aguilar, and her boyfriend, Daniel Garcia, were implicated in his death. Authorities believe that Garcia fatally beat Dominic in a San Antonio hotel room following the child's demise. Garcia and Aguilar transported his body to Colorado, where they disposed of it in a ravine. The couple then fled to Mexico and subsequently to Costa Rica. The case came to light when Aguilar's mother alerted authorities, leading to an investigation that uncovered the harrowing details. Aguilar later cooperated with law enforcement, leading them to her son's remains in Colorado. In May 2024, Daniel Garcia was convicted of injury to a child causing serious bodily injury for his role in Dominic's demise. During the sentencing hearing in August 2024, an emotional outburst occurred when David Engwiller, Dominic's biological father, confronted Garcia. Overcome with grief and anger, Engwiller shouted at Garcia, expressing his desire for retribution. Court bailiffs intervened, restraining Engwiller and escorting him out of the courtroom. Following this incident, the presiding judge sentenced Garcia to life in prison. Nicole Aguilar, who faced charges of injury to a child by omission, accepted a plea deal in exchange for her testimony against Garcia. She was sentenced to 15 years in prison. After 2 days of discussions, a jury convicted 3 men for the murder of the owner of a party store in Clinton Township, Kenneth Hill, 27, and Jomar Robinson, 26, both from Clinton Township, and Darius Diaz Gaskin, 25, from Detroit, were tried together in Macomb Circuit Court and found guilty of first-degree murder, armed robbery, felony firearm possession, and conspiracy to commit armed robbery.
To the my brother in cold blood, I say this to you. You're an absolute disgrace to the human race. I hope that while you spend the rest of your life in prison, you actually reflect on the awful decisions you've made in your life. You have the blood of a loving father, husband, son, and brother on your hands.
Hill, Robinson, and Diaz Gaskin were sentenced to life in prison without the chance of parole after being found guilty. A fourth man, Clinton Grayson, 26, from Detroit, had already been sentenced to life in prison without parole for first-degree felony murder and other charges. Surveillance footage from the store showed that during the 1-minute and 44-second attack on March 28, 2014, Diaz Gaskin, Robinson, and Grayson entered the Moonlight Party store on Harper around 11 p.m. Store owner Bassem Sulaka stood up, and within 20 seconds, he was struck in the back by a 9mm weapon fired by Diaz Gaskin. Bassem's sister, Vivian Sulaka, described him as a peaceful man who didn't keep a weapon at his store or have thick plexiglass for protection. During closing arguments, Diaz Gaskin's lawyer, Richard Glanda, claimed his client thought the gun's safety was on. However, the jury didn't believe this and found all 3 men guilty. As a result, Hill, Robinson, and Diaz Gaskin were sentenced to life in prison without parole. John Camfield, a former police officer from Mississippi, caused a tragic accident on April 27, 2017, in P County, Florida, while driving drunk. He struck a group of middle school students, ending the life of one and injuring 4 others. At the time, Camfield's blood alcohol level was 0.47%, nearly 6 times the legal limit of 0.08%. He was arrested and charged with DUI manslaughter and other related offenses. On May 31, 2018, Camfield pleaded no contest to the charges, stating that health issues, not alcohol, impaired him and that he couldn't remember the incident.
This was not intentional. This is not a drinking and driving issue. This was a medical issue.
Despite Camfield's claim, Judge Wayne Durden considered the case especially serious and sentenced him to 35 years in prison, 30 years for DUI manslaughter, and 5 years for causing serious injury. Camfield was also given 4 years of probation for other DUI charges. His victim, 13-year-old Jaheim Robertson, sadly passed away the day after the crash. Jaheim's parents, Alan and Robin Robertson, expressed immense grief and anger, holding Camfield accountable for their son's demise and criticizing him for not stopping to help the injured children.
That away from me. You took that away from my family. You took that away from his sisters.
Camfield's lawyer asked for a 4-year sentence, but the judge gave him the maximum allowed by state law. State guidelines suggested at least 16 years in prison. His history of alcohol problems was highlighted by his former supervisors and mentioned by Sheriff Grady Judd in a news conference after the crash. Ultimately, Camfield was sentenced to 35 years. Little Maynard Trappa Sparks was charged with murdering Travis Henry Jr., a 22-year-old from Montgomery, Alabama, on June 21, 2020. 2 women, Terriona Horton and Kalia Sumter, used Facebook to flirt with Henry and convince him to visit Columbus, Georgia. Sparks, Horton, Sumter, and another suspect, Wayman McMillian, allegedly robbed Henry and took his life. Horton and Sumter had arranged to meet Henry at Whisperwood Apartments on Flat Rock Road. The group first planned to rob Henry near a playground on Bay Avenue, but changed locations when it was too crowded. They later went to a dark area near the Farley Homes housing complex to carry out the robbery. Sparks pointed a weapon at Henry and demanded, "Give me everything you have." Henry, who had a weapon at his waist, likely reached for it, which led Sparks to fire at him in the upper torso. Sparks then pulled Henry out of the driver's seat, took his BMW, and drove it to Phoenix City, while the others followed in a Volkswagen. They left the BMW at a spot on Brickyard Road chosen by Horton, who had relatives nearby. Sparks wiped down the car with a shirt before leaving with the group in the Volkswagen. Later, they went to a boat ramp at Columbus's Rotary Park, where Sparks threw items he had taken from the BMW, including 3 iPhones and a diamond bracelet, into the river. Sparks was charged with felony murder, armed robbery, and using a gun during a crime. He was found guilty of all charges and sentenced to life in prison without the possibility of parole. His lawyer admitted that Sparks deserved to be punished.
Sentences the defendant to imprisonment for life without the possibility of parole. He will be severely punished. Everything in his life won't happen. It's going to be taken from him. And he deserves it. He did it himself. God didn't do it to him. The DA didn't do it to him. He did it himself.
After being sentenced, Sparks addressed the court, angrily criticizing his lawyer, the judge, and the district attorney. He questioned the reliability of the witness testimonies and even blamed the victim's family. Sparks insisted that the witnesses were lying and expressed frustration that the court accepted their accusations in a case that could cost him his life. Hernandez Martinez was convicted in March 2011 for his involvement in a gang-related double murder on July 13, 2008, outside Casa Tequila in Fairfield, Ohio. He was found guilty of 2 counts of aggravated murder, attempted aggravated murder, and gang involvement. Instead of the death penalty, Judge Michael Sage sentenced him to 78 years to life in prison, making him eligible for parole only at the age of 102. The jury had recommended 30 years to life for each murder. His defense attorney requested that the sentences be served concurrently, but the judge declined, calling the crimes severe. Judge Sage ordered the sentences to be served consecutively, with 30 years for each murder plus 18 additional years for other charges, bringing the total to 78 years to life. Throughout the trial, Hernandez Martinez consistently denied being in the car during the drive-by shooting.
I have a heart. I'm a human being.
He was not the shooter, his attorney argued in his defense.
You to please spare his life. He has many redeemable qualities. He's a man. He's a son. He's a father. He's not the one who killed these individuals.
The Butler County prosecutor called the sentencing a win for society, saying it sent a strong message to violent offenders about the serious consequences they could face, including life in prison. During the trial, Hernandez Martinez begged for his life, speaking in broken English with the help of an interpreter.
You guys to give me a second chance to live and to tell you guys who I really want to be.
He talked about the difficulties he faced in Mexico before coming to the United States. He spoke of his love for his young son and emphasized that joining the MS-13 gang was a mistake, not a reflection of him being a violent criminal. He explained that he got involved with the gang after becoming homeless and accepting help from its members, who gave him food and shelter. At first, he saw the gang as a joke, but over time, he felt trapped as they threatened his life if he didn't obey. Despite his testimony, his sentence remained unchanged. 19-year-old Austin Gregory Myers was convicted of murdering Justin Back, a childhood friend. Myers and his accomplice, Timothy Mosley, planned to steal a safe from Justin's house. Their first idea was to poison him with cold medicine. But when Myers' credit card was declined, they changed their plan. They decided to strangle Justin with a wire and make it look like he had run away with the safe. On the day of the murder, they bought cleaning supplies and gloves before heading to Justin's house. Mosley carried a wire and a knife, planning to strangle Justin while Myers distracted him. But when the wire slipped, Mosley panicked and Myers held Justin down while Mosley repeatedly stabbed him. Justin begged for his life, but Myers told him it would be over soon. After ending his life, they wrapped his body in a blanket, cleaned up the scene, and stole the safe along with other items, including a weapon. They put Justin's body in Mosley's car and later dumped it in a field in Preble County. Myers then poured chemicals on the body and fired at it twice with the stolen weapon before it jammed. They were arrested shortly after, and Justin's body was found the next day. An autopsy confirmed he passed away from multiple stab wounds. In February 2014, Myers was charged with aggravated murder, robbery, burglary, and other serious crimes, including abusing a corpse and stealing a firearm. Some of the charges made him eligible for the death penalty. Mosley, who was also charged, took a plea deal a week before Myers' trial and agreed to testify against him. Mosley pled guilty to all charges charges and avoided the death penalty. Myers' trial started on September 22, 2014, and on October 2, 2014, the jury found him guilty on all counts. The state chose to pursue the aggravated murder charge involving premeditation and robbery. During the penalty phase on October 6, 2014, Myers' family testified on his behalf, and he asked for leniency. Despite having no prior criminal record, the jury recommended the death penalty. On October 16, 2014, Myers was sentenced to death along with additional prison terms for his other crimes. The Ohio Supreme Court later upheld his conviction and sentence. Myers remains on death row at Chillicothe Correctional Institution. Mosley was sentenced to life in prison on November 14, 2014, and is being held at Ross Correctional Institution, which is across the street from Myers' prison in Chillicothe. Brandon Griffin led the squad gang in Manchester, New Hampshire, using violence to control the local drug trade. He was convicted of 53 crimes, including murder, assaults, and drive-by attacks, all carried out under his leadership. The gang's actions caused turmoil in the city, with Assistant Police Chief Ryan Grant noting almost nightly acts of gun violence during their time in power. During Griffin's trial, former gang members testified that he recruited them in 2015 and 2016, trapping them in debt for bail money or substances. To pay off their debt, they had to follow his orders, which included violent acts like attacking women, eliminating rivals, and opening fire on the homes of competing drug dealers.
Yet all the defendant was interested in was increasing his market share, and that's what it was all about. How much more money he could make, how much more territory he could...
On August 5, 2019, Griffin was sentenced to 48 years in state prison. This sentence was between the 277 years that prosecutors wanted and the 25 years suggested by his defense. His lawyers plan to appeal and have asked the judge to make public files related to allegations of misconduct by the prosecution. In 2016, 14-year-old Regginald Lofton was convicted of felony murder for his role in the robbery and fatal attack on pizza delivery driver Shane Varnador. On the night of March 1st, 2016, Lofton and his friend, 21-year-old Jermaine Young, tricked Varnador into delivering a pizza to an apartment complex in Lawrenceville, Georgia. When Varnador arrived, he was fatally wounded. Police later found him lying in a parking spot with an injury to his upper left abdomen. Both Lofton and Young were charged with felony murder, aggravated assault, and armed robbery. During Lofton's trial, prosecutors argued that he was involved by providing the cell phone used to lure Varnador, witnessing part of the crime, and taking the pizza back to his apartment after the murder. In his defense, Lofton claimed that while he was in the apartment with Young that night, Young planned and carried out the robbery. He said he was influenced by Young because of his age and backed out once he realized what was happening. Lofton was sentenced to life in prison with the possibility of parole after 30 years. During his court hearing, he was mostly silent, but before sentencing, he spoke briefly, saying, The judge, visibly frustrated, called Lofton a cold-blooded killer and said he wished he could give a harsher punishment. However, the law only allowed a sentence of life in prison.
I wish I could give you more time than I can because I think you're a cold-blooded killer. I hope you never get out of jail.
Lofton appealed his conviction, claiming that the trial court mishandled evidence and that his lawyer did not provide effective defense during the trial. However, the Supreme Court of Georgia upheld the conviction, ruling that there was enough evidence for the jury to reasonably find him guilty of felony murder during an armed robbery. Dexter Johnson was convicted of double murder in Harris County in 2006. Just days after turning 18, Johnson and 4 other teenagers carjacked Maria Aparez and Huing Go while they were sitting in a car outside Ngo's house. The group robbed them, took them to a remote area, and Johnson assaulted Aparez before he and another teen opened fire, ending both victims' lives. These murders were part of a 25-day crime spree by Johnson and his group, which also included 3 other killings. Johnson has been on death row since his conviction in 2007.
Dexter Darnell Johnson, the jury has found you guilty of capital. In accordance with the laws of the state of Texas, this court hereby assesses your punishment. Ladies and gentlemen of the jury, this is going to complete your jury service.
In his recent appeals, Dexter Johnson argues that he is intellectually disabled and should not be executed under U.S. Supreme Court rules. His lawyer points to updated IIQ and neuropsychological tests showing that his IQ is below the threshold for intellectual disability. The attorney also argued that medical standards for determining intellectual disability have changed since Johnson's trial, justifying a review of his case. Harris County prosecutors opposed Johnson's claim, noting that he had already raised issues like brain injuries or mental illness during his trial. They also referenced slightly higher IQ scores from that time and argued that Johnson is deserving of the death penalty. Less than 24 hours before Johnson's scheduled execution, a federal appellate court halted it. The court delayed the execution and sent the case back to a district court to review new claims about Johnson's intellectual disability. The district court will now examine these claims further. Jeffrey Morin, a former Missouri police officer, was convicted of 2 murders and a sexual assault. The first murder happened on November 5, 2008 in Harrisonville, Missouri. Morin broke into the home of Cara Jo Roberts, a 30-year-old mother, assaulted her, and fired at her. DNA evidence linked him to the crime, leading to his conviction for first-degree murder and armed criminal action. The second murder occurred on October 29, 2010 in South Kansas City. Morin ended the life of 75-year-old Nina Whitney, who was found strangled and stabbed. DNA from the scene matched Morin's. He initially refused to give a DNA sample, but one was taken later while he was in jail in Iowa, serving a sentence for Roberts' murder. Morin pleaded guilty to causing Nina Whitney's demise and was sentenced to 20 years for second-degree murder and 10 years for armed criminal action. This sentence runs at the same time as his previous sentence for Roberts' murder, where he got life in prison plus 50 additional years for using a weapon. Morin had left his job as a police officer due to Parkinson's disease. After trying to avoid capture, he was identified by his ex-girlfriend, Paige Huser, who recognized his composite sketch on a billboard. On January 8, 2011, U.S. Representative Gabby Giffords was holding a meeting called Congress on Your Corner in the parking lot of a grocery store in Tucson, Arizona, when suddenly bullets were fired. Giffords was struck in the head by a bullet from a Glock 19 9mm pistol. The perpetrator was 22-year-old Jared Lee Loughner, who had a strong distrust of the government and specifically targeted Giffords, but he didn't stop there. Pleased with what he had done, Loughner opened fire on the crowd, striking bystanders and taking the lives of 6 people, including Chief U.S. District Court Judge John R. Roll, a member of Giffords' staff, and 9-year-old Christina Green. Loughner was eventually tackled by an officer and taken into custody for questioning by the FBI.
I knelt down and put my knee in his back and pulled out my handcuffs and handcuffed him.
When asked about his motive for the crime, Loughner refused to speak and invoked his Fifth Amendment right, which allows him to remain silent. As a child, Loughner was caring, gentle, and kind, but as he got older, he began drinking heavily, using hallucinogenic substances, and became more detached from reality. One strange aspect of his life was his social media activity. Loughner was an active member of an online message board called Above Top Secret, known for discussing controversial topics. Surprisingly, even his posts were considered too extreme for this group and weren't well received by other members. He shared disturbing conspiracy theories, such as claiming that 9/11 was an inside job, that the government was controlling people's minds through grammar, and that a powerful elite group was trying to take over the world through a central banking system. At one point, he posted a video related to these beliefs.
How's it going? Thanks for the beat. I'm off. What's that? I lost my freedom of speech to that guy, and this is what happens. And I'm in a terrible place. It's the school that I go to. This is my school.
His odd behavior eventually led to his suspension from Pima Community College in September 2010, and he was also fired from several jobs for similar reasons.
I even forgot the teacher that gave me the B for freedom of speech. That's what my sociology class was. And then here's the microwave that I'll be using when I'm homeless. This is the cafeteria, they make illegal transactions. This is Pima Community College, one of the biggest scams in America. The students are so illiterate that it affects their daily lives. Here's the best part, the bookstore. The bookstore, the bookstore, the bookstore. It is so illegal to sell this book under the Constitution. We are also censored by our freedom of speech. They're controlling the grammar. They control the grammar.
On August 25, 2007, Lofton attended an event hosted by Giffords and was unhappy with her response to his question, "What is government if words have no meaning?" According to his parents, after the event, he often spoke about how women shouldn't hold positions of power and criticized Giffords as dishonest and fake. In November 2011, despite his poor job history, Lofton was able to buy the Glock 19 he used in the attack, along with other items, showing how powerful his hatred had become. However, he left clues about his plans. On the morning of the incident, he posted a strange message on his MySpace account. Lofton then took a taxi to a Safeway supermarket where Representative Giffords was holding a meeting. At around 10 a.m., he opened fire, injuring 19 people, including Giffords, who was critically hurt but narrowly survived. Lofton pleaded guilty to 19 counts, including the murder of 6 people and the attempted assassination of 13 others. By pleading guilty, he avoided the death penalty, though some victims' families were upset by this decision. In November 2012, Lofton was sentenced to life in prison, plus an additional 140 years in federal prison. He is currently serving his sentence at the Federal Medical Center in Rochester, Minnesota, spending the rest of his life under the control of the very government he despised. In June 2024, Nicholas Tartaglione, a former police officer, was convicted of kidnapping and murdering 4 men in Westchester County, New York. On April 11, 2016, Tartaglione tricked Martin Luna, who owed him drug money, into coming to a bar owned by his brother in Chester. Martin brought along 3 others, Urbano Santiago, Miguel Luna, and Hector Gutierrez. Tartaglione restrained and beat Martin for over an hour, demanding the missing money. When Martin couldn't pay, Tartaglione strangled him with a zip tie. The other 3 men were fatally wounded in the back of the head because they witnessed Martin's murder. Tartaglione buried all 4 men in a mass grave on his property in Otisville, New York. Tartaglione was convicted of several charges, including murder, kidnapping, and drug conspiracy. Prosecutors said 2 associates, Joseph Biggs and Gerard Benderoth, helped him threaten the men with a firearm. During his sentencing, Tartaglione denied the crimes, claiming he was a former officer who rescued animals and was framed. The judge disagreed, calling him a monster with no remorse. The judge referred to the overwhelming evidence and described the crimes as brutal, involving torture, planning, greed, and cover-ups. Tartaglione received 4 consecutive life sentences. His attorney plans to appeal, pointing to Tartaglione's history of rescuing animals and claiming he had compassion. Imagine this. It's a normal morning at the Cielo Vista Walmart in El Paso, Texas, a busy place near the Mexican border. Families are shopping, kids are playing, and the usual weekend crowd fills the store. Then, out of nowhere, Patrick Wood Crusius walks in, armed and ready to cause devastation. By 10:30 a.m., shots are fired, turning the store into a scene of panic and terror. Fast forward to the aftermath. Crusius, responsible for one of the deadliest hate-driven attacks in U.S. history, is in court facing justice, and the judge did not go easy on him. This 24-year-old, who ended the lives of 23 people and injured 22 others, was sentenced to 90 consecutive life sentences. That's right, 90. No parole. No chance of ever being free again. His crime wasn't just mass murder, it was fueled by hatred. Before the attack, he posted a hateful manifesto online, ranting about immigrants and targeting people based on their ethnicity. This wasn't a random act. He drove 650 miles from Allen, Texas to El Paso with the clear intent to take lives. In court, the charges piled up. He faced 45 counts of violating the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act, and another 45 counts for using a firearm in violent crimes. Each life sentence represented represented one of his victims, including Andre Anchondo, his wife Jordan, Margie Rickard, and many others who lost their lives. During sentencing, the victims' families spoke directly to Crusius. Tito Anchondo, who lost his brother and sister-in-law, talked about resilience and moving forward despite the tragedy. Paul Jemrowski, Jordan's father, shared the pain of being in the same room as the man who destroyed his family. Dean Reard, whose mother lost her life, traveled from Nebraska to make sure his voice was heard. The investigation that led to Crusius' conviction involved every major law enforcement agency: FBI, ATF, Texas, DPS, and more. The evidence against him was overwhelming.
I'm just following the lead that I've heard from the El Paso Police Department, where they say there are strong indications that this wrote that manifesto and that this was inspired by his hatred of people here in this community.
He openly admitted that he targeted people because of their ethnicity. There was no denying it and no way out. In the end, Crusius sat in the courtroom and listened as he was sentenced to 90 life terms with no chance of parole. Just think about the weight of that sentence. No cameras were allowed inside, but his face must have said it all. It was a moment of reckoning, a clear reminder of the consequences of his hate-driven actions. Montana Barnett, also known as Tana, led a violent gang called Train to Go, TTG, in West Baltimore's Santa neighborhood. Barnett became infamous for his violent actions, personally committing 6 murders as part of the gang's activities between 2010 and 2017. Along with his co-leader, Terrell Civils, Barnett was convicted of trafficking illegal substances after a 24-day trial. Evidence showed that TTG members carried out violent crimes, like murder, armed robbery, and witness intimidation to protect their drug territory, grow their power, and rise in the gang's ranks. One of their most notorious acts was a 2015 shooting near the University of Maryland-Baltimore campus, where Barnett and his group fired over 50 rounds, ending the lives of 3 people, including 2 innocent bystanders. They also threatened witnesses to stop them from cooperating with law enforcement. Prosecutors described Barnett as a ruthless killer who targeted anyone suspected of working with the police. At 23 years old, he was sentenced to life in prison for leading a criminal organization involved in murders, drug trafficking, and intimidating witnesses. Barnett's sentencing was announced by top officials, including Assistant Attorney General Brian Bowski, U.S. Attorney Robert Hur, and FBI Special Agent Gordon Johnson, who commended law enforcement for dismantling the gang and holding Barnett responsible for his crimes. Edgar Ray Killen grew up in the Deep South during the early 20th century, a time when racial segregation and white supremacist beliefs were widespread in the region. Killen worked in blue-collar jobs, including running a sawmill, which was common in rural areas and gave him a steady income. He also served as a part-time Baptist minister, giving him influence in his community, a role he would later misuse for harmful purposes. Killen's involvement in his community went beyond his work and ministry. He was a recruiter for the Ku Klux Klan, specifically for the Neshoba and Lauderdale County chapters. The Klan, a white supremacist group, was known for its violent tactics and terror campaigns against Black Americans and civil rights activists. As a recruiter, Killen helped organize local Klan activities. Killen's strong belief in white supremacy and his active role in the Klan led to his involvement in one of the most notorious crimes of the civil rights era. In the summer of 1964, during what became known as Freedom Summer, activists from all over the country traveled to Mississippi to help Black people register to vote and challenge the deep-rooted racial segregation. Among these activists were James Chaney, a 21-year-old Black man from Meridian, Mississippi, and Andrew Goodman, 20, and Michael Schwerner, 24, both Jewish men from New York. On June 21, 1964, Chaney, Goodman, and Schwerner were investigating the burning of a Black church in Philadelphia, Mississippi, when Neshoba County Deputy Sheriff Cecil Price arrested them. After being held for several hours, they were released late at night, only to be ambushed by a mob of Klan members. This mob was organized and led by Edgar Ray Killen. Using his position as a Klan recruiter and local preacher, Killen coordinated with Price and other Klan members to ensure the activists would be intercepted after their release. The mob, armed and prepared, caught up with Chaney, Goodman, and Schwerner and brutally murdered them. Their bodies were buried in an earthen dam. Mississippi showed little interest in prosecuting the people responsible for the murders, but the federal government, led by Attorney General Robert F. Kennedy and the FBI, began a strong investigation. The case, known as the Mississippi Burning Case, gained national attention and brought focus to the violent resistance to civil rights in the South. Killen's role as the leader behind the murders was confirmed by Samuel Bowers, the Grand Wizard of the local White Knights of the Ku Klux Klan. Bowers admitted that Killen was the main person who planned and carried out the murders. Despite the clear evidence, the initial efforts to bring Killen and his co-conspirators to justice faced major challenges, including an all-white jury and a deeply segregated legal system. For many years, justice seemed impossible. However, the hard work of journalists, activists, and a new wave of civil rights advocates helped revive the push for justice. One important figure in the case was Jerry Mitchell, an investigative reporter for the Clarion Ledger in Jackson, Mississippi. Mitchell's in-depth research and reporting brought new attention to the case, uncovering fresh evidence and witnesses. In early January 2004, a diverse group of citizens in Neshoba County formed the Philadelphia Coalition, focused on seeking justice for the 1964 murders. Their efforts reached a peak on the 40th anniversary of the murders, when over 1,500 people, including Mississippi Governor Haley Barbour and Congressman John Lewis, gathered to demand justice. The growing pressure led to action, and on January 6, 2005, a local grand jury indicted Edgar Ray Killen for the murders. At the time, Killen was 80 years old. He was arrested and charged with 3 counts of murder. His trial was originally set for April 18, 2005, but was delayed after he broke both legs while chopping lumber. The trial eventually started on June 13, 2005, with Killen attending in a wheelchair. On June 21, 2005, exactly 41 years after the crime, Killen was found guilty of manslaughter. The jury, which included 9 white jurors and 3 black jurors, rejected the murder charges but found Killen responsible for recruiting the mob that carried out the crimes. Circuit Judge Marcus Gordon sentenced Killen to a maximum of 60 years in prison, 20 years for each manslaughter charge, to be served one after the other. Count 1, it is the sense of this court that you serve 20 years in the custody of the Mississippi Department of Corrections. And count 2, it is the sense of this court that you serve 20 years in the custody of the Mississippi Department of Corrections, with this sentence to run consecutively to the sentence pronounced upon you in count 1.
In count 1, it's the sentence of this court that you serve 20 years in the custody of the Mississippi Department of Corrections. In count 2, it's the sentence of this court that you serve 20 years in the custody of the Mississippi Department of Corrections, with this sentence to run consecutive to the sentence pronounced upon you in count 1.
Killen would have been eligible for parole after 20 years, but given his age, it was unlikely he would ever see freedom again. In his sentencing comments, Judge Gordon stressed the value of each life lost and emphasized the importance of giving the maximum sentence regardless of Killen's age. The prosecution, led by Mississippi Attorney General Jim Hood and Noxubee County District Attorney Mark Duncan, had managed to bring some justice to the families of Cheney, Goodman, and Schwerner. Throughout the trial and sentencing, Killen remained mostly emotionless, showing little reaction. He chose not to testify in his defense and did not apologize or show any remorse for his actions. Aleio Bishop, also known as Nature Boy and Three God, is the leader of an alleged cult called Carbon Nation. In April 2022, he was arrested in DeKalb County, Georgia, following accusations from a former member who reported that Bishop had raped her when she attempted to leave the group and subsequently posted explicit videos of her online without her consent. In March 2024, after a jury trial, Bishop was convicted on multiple charges, including rape, false imprisonment, and 3 counts related to the unlawful distribution of explicit material. The court sentenced him to life in prison without the possibility of parole, plus an additional 10 years.
I am going to follow the recommendation of the state in this case. He'll be sentenced to life without the possibility of parole, followed by 10 years consecutive for the false imprisonment. And on the internet, count 3, 12 months to serve, concurrent to the false imprisonment. The internet concurrent to the false imprisonment. Internet 5 years, so it's 12 months on count 3, 5 years on count 4, and 5 years on count 5. All of that will run concurrent to the false imprisonment, but the false imprisonment is consecutive, so it's life without parole plus 10 years. And hopefully he will never be able to take advantage of anybody else again.
Judge, can you be sure to go over his post-conviction rights with him as well as his...
Yes.
I was just going to put those on the... And Judge, before, I know there were certain conditions, obviously with the way the law currently exists and the court's sentence, the defendant will not be out. Just in case the law changes in the future, we would ask that the conditions of no contact with any of the victims and that the defendant may not profit financially in any way off of the facts that led to this case.
All right, Mr. Bishop, you're to have absolutely no contact, direct or indirect. That means sending any of your followers to contact them, getting any messages to them, no posting, no internet posting about them, no contact, direct or indirect, no phone calls, emails, no nothing, no visits to their homes, nothing, zero. They don't exist anymore. And you are not to profit in any fashion from the crimes that you have committed. So no book deals for you, no movie rights, nothing. And also with respect to your appellate rights, let's see, you have 30 days, I believe, from today to file a motion for a new trial.
That's correct, Judge, and I'll get him a boilerplate motion for a new trial file once the sentence is filed.
He has 30 days from the date of his sentencing, which is today, to file a notice of appeal or a motion for a new trial to preserve his direct appeal rights. He also has 4 years from the time that his conviction becomes final to apply for a petition for a writ of habeas corpus. Generally, a conviction is final when all direct rights have expired.
Okay.
And he has 1 year on the misdemeanor.
Right. That's right, the one.
During the trial, testimonies from former members described the abusive dynamics within Carbon Nation, highlighting Bishop's manipulative and controlling behavior.
I wasn't able to go. I felt like I couldn't. I felt powerless. And he kept telling me that he wanted to just do it one more time, just one more time.
I was basically his disciple, and then he would make me his lover and take me and become his wife.
What the defendant did with that power, the answer to that, the evidence will show, is sex. Nobody said no to the king.
While serving his sentence at Macon State Prison, Bishop was involved in an altercation in August 2024, which led to his hospitalization. He sustained non-life-threatening injuries and was treated at a local hospital before being returned to the prison.
You will hear that there was this atmosphere of fear and violence within the group, waiting for the other to drop. Who was going to be?
She packed her bags. Nobody stopped her from packing her bags on her. She was able to get her paintings out of the storage. Nobody stopped her from doing it.
The Georgia Department of Corrections confirmed the incident and stated that it was under investigation. Bishop had previously garnered attention through a significant social media presence, where he promoted his beliefs and lifestyle associated with Carbon Nation. The group's activities and Bishop's leadership have been subjects of controversy and legal scrutiny over the years. In 1987, Stephen Gary Jones was fatally injured outside the Duck's Breath Bar and Lounge in Warner Robins, Georgia. The case remained unsolved for 27 years until 2014, when Warner Robins police announced a breakthrough. They indicted Willie Lewis Winters for felony murder and malice murder in connection with Jones's demise.
2016, no new evidence. July 24th, 1987. DA, Fight, Lieutenant Barrett, Major Dan Hart, Sergeant Galen Knoll, Detective Kenna Paca, and I met at Zare Plaza at 8 a.m. to begin the reconstruction. After Fight reviewed the evidence, he could not determine positively who had fired first. However, he felt that Winters approached the driver's side of the vehicle after being at the passenger window. Then Jones exits his car with his pistol, and the fight ensues.
The verdict on count 2, is that correct? If you will hand the verdict form to the bailiff, please. As for you, count 2, the verdict reads as follows. We, the jury, find the defendant guilty felony murder this 15th day of July. Mr. Moore as foreperson. Anything else for the jury before we excuse them?
Nothing to say. I'd like to ask you to hold the jury.
I will hold the jury again in light of the previous announcement so that we are all on the same page. Ms. Daniels, is this your verdict now?
God let it happen with.
At the time of the indictment, Winters was already serving a life sentence at Central State Prison for a 2004 murder in Crawford County. The Duck's Breath Saloon, located on Watson Boulevard between Warner Robins and Centerville, was a popular venue in the late 1970s and 1980s, known for hosting Southern rock musicians and attracting large crowds. The reopening of the cold case and subsequent indictment of Winters brought renewed attention to the decades-old crime, highlighting the persistence of law enforcement in seeking justice for long unsolved cases. In 2019, 76-year-old former teacher Robert A. Goodlin was sentenced to 3 years in a New Jersey state prison for sex offenders after pleading guilty to 2 counts of second-degree sexual assault. Goodlin admitted to repeatedly assaulting 2 male students over a decade, with incidents occurring at the victims' homes, in his vehicle, and at his cabin in West Milford. The assaults took place during the 1990s while he was teaching industrial technology at Joseph Batten School No. 4 in Elizabeth, New Jersey. Goodlin's teaching career spanned multiple North Jersey schools, including Secaucus High School, where he taught industrial arts and coached track, and Thomas Edison Career Academy in Elizabeth, where he instructed an auto body class. He also had a teaching stint in Cresskill.
Mr. Goodlin, sir, is there anything you want to say to this court before I impose sentence on you?
I would just like to say that I'm sorry for anybody that I've inconvenienced, and I would like to say that I'm sorry for anything that I've done to hurt my family, my 3 children, my 8 grandchildren, and I want to get help myself that I can be a better American, a better citizen, and a better Christian. And I'm willing to take whatever's coming my way in order to be that type of a person. Continue on the life of being productive. I've had a very rough life, and I'm going through a lot, and medically I'm taking a dive. As you can see, I just had cancer. It's running all through my head. They can't control it. And like I said, I'm a strong person, and I will deal with whatever. I want to say that I love my wife, and she's been with me through this whole mess. And said, it's rough on the family and everything, and I'm very sorry. I want to show remorse to anybody that I've hurt or done anything that I should have done. I have a few bad judgments, and that's pretty much it.
Although the defendant pled guilty to 2 men who were students of his in the Elizabeth Public School System, the words he used today were inconvenience. I'm sorry for this inconvenience and my bad judgment. And he apologized, and he apologized to his wife, his family, his children, and his grandchildren. But there has been no apology to either of the men for which this indictment covers the abuse. And I think that speaks volumes. Mr. Goodlin admitted that he was a teacher, that AM was in the 7th grade, and that Mr. Goodlin performed oral sex on AM. Mr. Goodlin acknowledged that he was aroused and that he had fantasies about the 7th grader. When Mr. Goodlin was asked if he believed his behavior was wrong, he said, yes, I knew it shouldn't happen, Again, however, he told the interviewer, the medical professional, that the victim, quote, encouraged it.
In addition to his prison sentence, Goodlin faced civil litigation. In 2017, the Elizabeth Board of Education agreed to a $600,000 settlement with a former student who alleged that Goodlin assaulted him over 3 years. Lee Manuel Rios, a member of the Latin Kings gang, was convicted of taking the life of 18-year-old Kenneth Lopez in Springfield, Massachusetts, on March 24, 2015. Rios fired at Lopez, whose body was discovered the next day in a North End backyard. Rios was found guilty of first-degree murder for planning the crime and acting with extreme cruelty. He also faced charges for gun violations, conspiracy, and drug offenses. Judge Mark D. Mason sentenced Rios to life in prison without parole, plus 14 to 15 years for improperly storing a large-capacity firearm.
As to count one, jury having convicted you of first degree, sir, I am sentencing you to NCIC junction for the term of your life without the possibility of parole.
Lopez and Rios were both members of the Latin Kings gang, but had a falling out. Rios tricked Lopez into leaving his house with help from other gang members. During a raid on Rios's apartment, his brother Nelson Rios and Natalie Rivera were arrested and charged with weapon and drug offenses. Jordan Wade was convicted of several serious crimes, including 4 counts of aggravated murder, attempted murder, burglary, robbery, and kidnapping. Wade, who was 16 at the time, was tried as an adult after a juvenile court judge decided to transfer his case. He was arrested after a fatal incident at a home on East Houston Street, where the victims were identified as Michael A. Ballure, Daniel Sharp, Angela D. Harrison, and Tiaja Nelson. Ballure lived in the home, while the others did not. Police found a teenage girl injured outside the home, bleeding on the sidewalk. She told officers someone was dead inside, and when they entered, they discovered the 4 bodies. The girl, who survived the attack, identified 28-year-old Robert L. Adams Jr. as the assailant. She said Adams and Wade had robbed the victims in the kitchen before forcing them into the basement. She overheard Adams ask Wade if he should get rid of them all, and Wade replied, yes. After the attackers left, the girl managed to get out of the house and find help. To protect her safety, prosecutors requested that her name not be made public. Adams was indicted for the death penalty, but Wade, being a minor at the time, could not face the death penalty due to a U.S. Supreme Court ruling. Wade was sentenced to 172.5 years in prison, with 4 consecutive 30-year to life sentences for the murders and additional time for other charges. In April 2019, Wade was resentenced to 172.5 years to life after the court reviewed his gang involvement and found that he had actively encouraged Adams to commit the crimes. He is currently serving his sentence at Ross Correctional Institution. Adams pleaded guilty and was sentenced to life in prison without the possibility of parole. In January 2025, Natalie Cochran, a former pharmacist from West Virginia, was convicted of first-degree murder for the 2019 death of her husband, Michael Cochran. Prosecutors argued that she administered a fatal dose of insulin to prevent him from discovering a $2 million Ponzi scheme she was operating. At the time of her conviction, Cochran was already serving an 11-year federal prison sentence for wire fraud and money laundering related to the same scheme. The jury deliberated for less than 2 hours before delivering the guilty verdict. Cochran faces a life sentence, with the jury determining her eligibility for parole after 15 years.
But he was determined to find out, because people were saying, hey, we invested in your company in this plan, and we're not getting our money back. And he was frustrated. He was very frustrated. But the same excuses provided by the defendant to all of her victims in the Ponzi scheme were being provided to Michael Cochran too. It's everybody's fault under the sun. They've got hundreds of millions of dollars in their money stuck in a bank in Virginia, Bank of America. That's what she told Michael Cochran. That's what he believed. So Michael Cochran is going to straighten this out. They charter a flight from Beckley to the Bank of America branch in Lynchburg, Virginia for the 6th of February, 2019. Mysteriously, the defendant cancels that trip in early morning hours. Why was that trip so important? Because Michael Cochran and everybody else would know at that point. There is no money in the Bank of America in Virginia. There's never been any money in the Bank of America in Virginia. There are no government contracts, which is what she was selling to most of Raleigh County, it seems like. Those were fictitious things that she made up and built millions of dollars out of her victims. Now, we're not going to pretend Michael Cochran didn't get a benefit from this. He did. The defendant and her family lived a very lavish lifestyle with other people's money. And Trooper Heinzman will explain to you in an overview, because this case isn't the Ponzi scheme case. That one's over. This is the murder case. But he'll explain to you how the defendant did this and how she was able to pull this off for so long and how she got so many people to forfeit their money to her. That was all going to blow up on February 6th. And it would have been over February 6th. But of course, the Cochrans never made it from Beckley to Lynchburg. And Michael Cochran is because of this. By the way, in case you've forgotten from some of your questioning, this defendant is a pharmacist. She knows about medications and drugs. Beyond that, she held herself out as a specialist in diabetic counseling. She knew the impact insulin would make. That's our case. All circumstantial, and at the end of it, we'll be asking you to find the right verdict and find this defendant guilty of first-degree murder.
From 2017 to 2019, Cochran defrauded investors by posing as a government contractor through her companies, Technology Management Solutions and Tactical Solutions Group. She solicited funds under the pretense of securing lucrative government contracts, but instead used the money for personal expenses, including purchasing real estate, jewelry, and a 1965 Shelby Cobra. When Michael Cochran grew suspicious about their finances, Natalie chose to poison him rather than reveal her fraudulent activities. She claimed he was unwell but refused to seek medical attention, allowing him to sleep it off, which led to his death 5 days later. In October 2022, Charles Wright was involved in a fatal incident at the USA Food Mart on East 123rd Street in Cleveland. Following a verbal altercation with a 30-year-old man inside the store, Wright left, returned with a weapon, and opened fire. He fired at the man in the thigh, a 40-year-old woman in the ankle, and fatally wounded 60-year-old store employee David Gunn, who was stocking coolers at the time. The incident took place in broad daylight while approximately 9 customers and 3 employees were inside the store, causing panic in the community. Wright fled the scene on foot. Nearly a month later, on November 21st, 2022, the Northern Ohio Violent Fugitive Task Force arrested Wright while he was sitting in a vehicle near Parkwood Drive and Pasadena Avenue in Cleveland, U.S.
That is a felony of the first degree. There is a 3-year firearm specification in that count that has to be served consecutive to the firearm specification in count 3. He will be sentenced to 10 years in count 2.
Count 6, Judge?
I'm sorry, count 6. Turning to count 9, there's also that 3-year firearm specification that has to be served prior to and consecutive to the underlying offense, which is attempted murder, to which he'll be sentenced to 10 years. With regard to count 12, there is that 3-year firearm specification that has to be served prior to and consecutive to the underlying offense, to which he will be sentenced to 10 years. In count 14, there is a 3-year firearm specification that has to be served prior to and consecutive to the underlying offense, to which he will be sentenced to 10 years. Count 16, the 3-year firearm specification must be served prior to and consecutive to the underlying offense, to which he'll be sentenced to 10 years. Count 18, there's a 3-year firearm specification that has to be served prior to and consecutive to the underlying offense, to which he will be sentenced to 10 years. Count 20, there's a 3-year firearm specification that has to be served prior to and consecutive to the underlying offense, to which attempted he'll be sentenced to 10 years. Count 22, discharge of a firearm on or near a prohibited premises. There's a 3-year firearm specification that has to be served prior to and consecutive to the underlying offense.
Judge, there was no firearm specification attached to count 22.
Okay. With count 22, it's still a felony of the first degree. He'll be sentenced to 10 years. With regard to count 24, it's having weapons under disability. He will be sentenced to 12 months on that count. So the firearm again merges the two in count 1 and count 6. That's 6 years of firearm specifications for a total sentence of life in prison with the possibility of parole after 36 years. Parole eligibility is determined on life sentences by the parole board, but in an abundance of caution, I am going to go over Reagan Tokes in the remaining counts, which are counts 6, 9, 12, 14, 16, 18, 20, and 22. So I imposed a 10-year sentence on those counts, so that would be the minimum sentence of 10 years. The maximum sentence would be 15 years, which is half of the sentence that I've imposed. And again, this is just precautionary, but there is a presumption that you'd be released after the minimum time is served in those counts. However, ODRC has the legal right under Senate Bill 201 to rebut that presumption and extend your period of confinement for 50% of the term I've imposed. If ODRC makes that decision, you'll be released after the additional time is served. The decision to extend your term in these counts is the sole authority of the ODRC, and they alone make the determination based on such criteria as your conduct while incarcerated, your rehabilitation, the threat they believe you pose to the community, whether any restrictive housing sanctions were imposed on you during your incarceration, as well as your security classification. The ODRC also may choose to make specified determinations and monitor your incarceration more than one time in accordance with ORC 2967.271. Again, I want to make it clear, though, that count 1 does trump those counts, so the parole board will determine when you are eligible for parole once the 36 years have been served. And again, out of abundance of caution, I'll go over the post-release control of these other counts. And that is, with a felony of the first degree, there is a mandatory minimum of 2 years to a maximum of 5 years of post-release control under conditions determined by the parole board. If you violate the terms and conditions of post-release control, then they can send you back to prison for up to 9 months for each violation of the rules and up to 50% of your stated prison term. You will receive credit for all time served. I'll recognize that you're indigent and waive any court costs. You've requested an appeal. Appellate counsel will be appointed for you based on the list that the Court of Appeals provides. There's a list of assigned attorneys. Anything further for the record?
Yes, Judge, just to be clear, the sentences imposed, other than the 3-year firearm specification for count 6, but the underlying sentence for counts 6, 9, 12, 14, 16, 18, 20, 24, and 22, are those all concurrent to the sentence on count 1?
And I apologize for not saying that. They will run concurrent. Aside from the firearm specifications, the remaining counts will run concurrent to count 1, with the exception of the firearm specification in count 1 and 6, which are required by law that I run consecutive to each other. Thank you. Anything further on behalf of Mr. Wright?
Just respectfully ask the court to note our objection to any application of Reagan Tokes. Thank you.
It shall be noted.
Thank you.
Thank you.
In September 2023, Wright was found guilty on multiple charges, including aggravated murder, and was sentenced to life in prison with the possibility of parole after 36 years. Marshal Pete Elliott stated, "This senseless act of violence resulted in the death of a hardworking good man. The efforts of our task force last night brought these victims' families one step closer to the justice they deserve." On March 9, 2011, in East Providence, Rhode Island, 50-year-old Susan L. Benedetti struck teenager Brooke Gagne with her vehicle while driving under the influence. The incident left Gagne seriously injured.
You take your victim as you find her, and you cannot mitigate or avoid responsibility by suggesting that she is among the more fragile people, susceptible to injury.
My name is Brooke Gagne, and I was hit by a car on March 9, 2011, at 14 years old. Before March 9, I lived as a normal 14-year-old. I hung out with my friends every day and went to high school on a daily basis. I was in the 9th grade and was taking college prep classes. That was a usual day at night for me. After March 9, 2011, everything was completely different. I realized I couldn't move my legs, my arms, or my hips, and I couldn't lift myself up to see what was going on. Life for me is a lot more difficult and different now. Every day walking for me is a struggle. Yes, I can walk, but it hurts. I feel stupid, like I'm 3 years old, not being able to use the bathroom by myself. At school, I have to deal with other kids asking me what the scars on my body are from. Paying for a crime I didn't commit. I have a life sentence, but I never had a person on the side of the road that made me debating whether I could mentally handle being hit by a car.
Not only with my child, but with the disruption that it's caused in my own life, I've also had to hear public comments from the driver that were so disturbing and so, I can't even articulate in words the public display of human behavior. I truly believe over this past year that she has not a clue the impact and the destruction that she caused in my entire
punishment in this case is that the court imposed the full cap, the full sentence. That would be fair.
Go ahead.
I know it doesn't mean a thing at this point, but if I could take that day last year, I would give anything. And as far as remorse, I did not mean to hurt you with things I said. I thought I've never been into anything like this in my life. I made some bad choices and just tried to reach out to say I was sorry. And as far as the Facebook, I thought it was a private forum. I did not mean for anything to be taken the wrong way. Remorse is something I definitely feel every day.
Benedetti was subsequently charged with driving under the influence, causing injury. On April 24, 2012, Superior Court Judge Nettie C. Vogel sentenced Benedetti to 1 year in prison, followed by 4 years of home confinement. In Lorain, Ohio, 36-year-old John Donnie was sentenced to 6 months in jail after being convicted of animal cruelty for hanging his 130-pound mastiff, Memphis. Donnie pleaded no contest to charges of injuring animals and cruelty to companion animals.
Does the state wish to be heard before it pronounces?
Your Honor, I happened to see with some pictures that Officer Brose's investigation showed me, and I wish I had never seen those pictures because I'll probably always remember them the rest of my life. I can't see of a reason not to give him the maximum sentence, Your Honor.
I'd also entertain a motion to amend the charge to the revised code.
Yes, Your Honor, I would move to
the analogous section of the Ohio revised
Yes, Your Honor.
That motion would be granted.
Thompson, anything you'd like to say before I pronounce that?
Just briefly, Your Honor, thank you, and may it please the court, Your Honor. I was able to view the pre-sentence investigation in this case. I do understand that he does have somewhat of a criminal history, Your Honor. I know that you've seen it as well. I understand that this is a kind of case that garners a lot of attention. Your Honor, I know that my client wishes to address the court personally and express his regret. I do believe that both of these counts would be allied, Your Honor, so I believe that the maximum sentence would be 6 months. I know he has a little bit of credit. My suggestion, Your Honor, would be maybe to suspend at least some of the time, and maybe so that maybe the court would then have a tool to use to maybe impose some directives upon my client to make sure that he doesn't do anything like this in the future. And then way you can have that time being over 7 in case he doesn't comply, Your Honor. Although I do understand that this type of crime is very difficult for the court and for the public.
Lorain Municipal Court Judge Thomas Elwell delivered the sentence, expressing disbelief at the cruelty displayed toward the innocent dog.
Mr. Downey, anything you'd like to say?
I'm very sorry, and I regret what I have done. I'm sorry on behalf of the court and on behalf of the whole United States. I'm sorry. I won't do it no more.
Mr. Downey, this is a very troubling case. Very troubling. I find it just hard to understand how a person could treat a living, breathing creature, a defenseless creature, so with such cruelty. It just boggles my mind. I don't understand what would go through a person's mind before they would take that type of action.
Felix Lopez.
Just very disturbing. And you also have a criminal history that involves offenses of violence. So I really have no choice, really, in my view. And that is to impose the maximum sentence in the case. So it will be the judgment and law and sentence of this court that you be sentenced to 250 in costs and 180 days in the Lorain County Correctional Facility on count 1. Count 2 will be 90 days in jail, but you're correct, Mr. Thompson, they're allied offenses, so that will be concurrent to count 1.
Prosecutor Jeffrey Sabo had urged the court to impose the maximum penalty for the crime. In December 2017, the remains of Jordan Rodriguez were discovered buried in the backyard of his mother's residence on West 80th Street in Cleveland, Ohio. The boy's mother, Larissa Rodriguez, and her boyfriend, Christopher Rodriguez, were arrested in connection with his death. Investigations revealed that Jordan, who was nonverbal and born prematurely, had suffered severe abuse, including broken ribs, before his death in September 2017. The couple concealed his body for months before it was uncovered following a tip from Christopher's brother, who was stationed overseas. During the sentencing, Judge Russo, visibly emotional, remarked, "In 22 years, I never showed emotion. This is one of the worst things I've seen in my life." Neither defendant offered an apology or statement during the proceedings.
First, I want to say that the serviceman who made this phone call, it's so important that he did that, and I don't want him to go unrecognized, because I can't imagine the trauma that he had hearing this in a foreign country, that his brother had done something like this, asking his brother to take accountability, and then because his brother doesn't want to be a man, he has to do it, but he did it, and I give him credit for doing that. The other thing that this case, I think, really drives home is that there's insufficient consideration given to the people that work in the criminal justice system. So I want to say to the police, to the detectives Remington and Diaz, I certainly know that your job is very difficult. And I look at these photographs, and it's very hard. And I think you should be recognized more for the difficulty of what you do. And the same to the state. And to the defense, this is equally difficult for you. What we do every day is so hard. People don't give any of us the credit that we deserve for dealing with the horrors that are brought before us. And Mr. Rodriguez, this is a horror. I know as a judge I'm not supposed to show emotion. And in 22 years I never have. This is one of the worst things I've ever seen in my life. And I don't understand, Mr. Rodriguez, why you don't want to cleanse yourself and tell the truth about what happened here. And I hope someday you do. Whatever this child's life was supposed to be, you make sure it didn't happen. You and Larissa. I look at friends and family, people who are desperate to have children and want to have families, and you two have babies with no consideration. You just keep having them, disregarding the value of their life, disregarding their purpose in life, like they're less than an object, no regard. I didn't even hear you say you were sorry. I will not accept the recommendation for Mr. Rodriguez. These crimes are horrific. There's no question in my mind that this child was abused. It's clear that you did everything you could, you and Larissa, to hide evidence to protect yourselves. You had every opportunity at so many points to make a difference, to get help, to stop beating somebody, to call the police, to ask for help, to try to take him to the hospital. I have to imagine that at some point you got on the internet and said, how do I bury a body? Because this is unbelievable to me. The level of meticulousness that you went through to not be discovered. I honestly don't know how you live with yourself.
In June 2018, both Larissa and Christopher Rodriguez pleaded guilty to charges of involuntary manslaughter, felonious assault, endangering children, and gross abuse of a corpse.
Meticulousness that you went through to not be discovered. I honestly don't know how you live with yourself. I don't know how either one of you live with yourself. The court imposed a sentence as follows. Count 1, involuntary manslaughter, felony of the first degree, 11 years in prison. Count 2, felony of the second degree, felonious assault, 8 years in prison. Count 3, felony of the second degree, 6 years in prison. Count 5, abuse of a corpse, felony of the fifth degree, 9 months in prison. Counts 1, 2, and 3 to be served consecutive to each other and concurrent to the sentence imposed in count 5 for a total sentence of 25 years. The sentence is to be served concurrent to the sentence previously imposed in 625-508 for a total sentence of 25 years. Your sentence as follows. Count 1, involuntary manslaughter, 11 years in prison. Count 2, felony of the second degree, felonious assault, 8 years in prison. Count 3, felony of the second degree, 8 years in prison. Count 5, abuse of a corpse, 1 year in prison, all counts to be served consecutive to each other with credit for any time served. That's a total sentence of 28 years. That's the maximum sentence available.
Cuyahoga County Common Pleas Court Judge Nancy Margaret Russo sentenced Larissa to 25 years in prison and Christopher to 28 years, the maximum possible sentence for his charges. In Columbus, Ohio, a 70-year-old man, Terry McFadden, was sentenced to 22 years in prison after pleading guilty to 2 counts of assault involving 2 children. The incidents occurred in his home, which also served as a residential daycare operated by his wife. McFadden was arrested in April 2019 following accusations of sexually abusing the children. During the sentencing, the victims' parents expressed pride in their daughter's bravery in coming forward, emphasizing the importance of listening to and believing children. They shared their story to encourage other parents and caregivers to take similar action when necessary.
Mr. McConvicted of or pleaded guilty to a oriented child victim offense. As such, you will be a Tier 3 registrant for your lifetime with in-person verification every 90 days. failure to register, failure to verify residence at the specified times, or failure to provide notice of a change in resident address or other required information as described above will result in criminal prosecution. This court is so sick and tired of seeing adults ruin innocent children. These are literally just one step from being babies. They come to a daycare, those parents struggle so that when they release their children to someone during the day, they have some semblance that that child is going to be protected and safe. Not let alone 2 of their children being by your own admission, sir. For gratification, you a 4-year-old and a 6-year-old. I do not know at this time what the total ramifications will be for those 2 young children, but there isn't anybody who doesn't understand now the developmental phases of children take place from 0 to 6 years old. You can't even know what damages you've done for gratification. This to me is so mind-boggling that you used 2 little children like they're inconsequential beings. Those are human persons with human dignity. The mere fact that they're small little people that can't fight off adults, that's why an adult left them with adults. I'm going to tell you something, Mr. McFadden, there's no free in my courtroom. On count 1, I'm sending you to prison for 11 years. On count 4, I'm sending you to prison for 11 years. They will be consecutive to each other for a total of 22 years. You have 32 days jail credit. At this time, the court finds it necessary to protect the public from future crimes, to punish the offender, and to find that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. Folks, if you see it, you smell it, you know it's happening, you report it. These are little children that are the future. I hate to sound so cliche, but the children are our future, and if we're destroying them, we have no future. And this ends in this courtroom. That'll be all. Fines and costs are waived.
Upon release, if he survives his prison term, McFadden will be required to register as a Tier 3 sex offender for the rest of his life. In June 2016, during a sentencing hearing in Pretoria, South Africa, Oscar Pistorius, the former Paralympic athlete, removed his prosthetic legs and walked on his stumps in the courtroom.
And the pervasive effect of the disability on his subjective thinking. He proceeded to the entrance of the bathroom because of his excessive fight response and his inability to run away. My lady, all these facts are factual findings, not disturbed, and where the Supreme Court of Appeal made different findings, we included them here. He was armed with a heavy caliber firearm ready to fire. His perception that he and the deceased were in danger was fortified by the following. The open bathroom window, which explained the noise he had heard. So it's not that there was nothing. Of course there was. It's factual findings. The fact that there were ladders outside his house, as his house was being painted at the time, which would have facilitated access to the bathroom. He had heard the slamming of a door and subsequently saw that the toilet door was in fact closed. He believed that the person in the toilet was an intruder and that the deceased was at the time in the bedroom. He fired 4 shots into the toilet door with a downward trajectory, thereby not aiming at chest height. Although he may have been anxious and although frightened, his belief that he was entitled to fire was not rational and therefore not genuine. And that's where I stop. When I look at him and I think, how rational can it be, my lady? And if he may go back. I see that it's stressful for him if he may go back.
This demonstration was orchestrated by his defense team to illustrate his physical vulnerability without his prosthetics, aiming to elicit leniency in his sentencing for the murder of his girlfriend, Riva Steenkamp. Pistorius, known as the Blade Runner for his carbon fiber prosthetic legs, had his lower legs amputated as a baby. In 2013, he fatally injured Steenkamp through a locked bathroom door in his home, claiming he mistook her for an intruder. Initially convicted of culpable homicide in 2014, the conviction was later upgraded to murder upon appeal.
And that's the point, and that's the Ferreira's case where I'm at, my lady, where we get to this point. Although he may have been anxious and although frightened, his belief that he was entitled to fire was not rational. For purpose of conviction, I accept that, my lady. I accept that. That's the Supreme Court's appeal finding. That's fine. It's on law principles. But what are we dealing with when we look at that rationality? We're dealing with a person that's not like me. It's not like her, it's not like her. It's a person with, I don't want to overplay vulnerability. That's not what I want to do. I don't want to overplay disability, but the time has come.
During the 2016 hearing, Pistorius's lawyer, Barry Rue, requested the demonstration to emphasize Pistorius's perceived vulnerability at the time of the incident. The defense argued that this vulnerability contributed to his fear and reaction, suggesting it should be a mitigating factor in his sentencing.
Mr. Pistorius, please stand up. Having regard to the totality of this evidence, in this matter, the unanimous decision of this court is the following. 1. On count 1, murder read with section 51(1) of the Criminal Law Amendment Act 105 of 1997, the accused is found not guilty and is discharged. Instead, he is found guilty of culpable homicide. On count 2, contravention of section 127 of the Firearms Control Act, number 60 of 2000, and the alternative count, that is contravention of section 123B of the same act, the accused is found not guilty and discharged.
However, the prosecution contended that Pistorius had not shown genuine remorse and that a severe sentence was warranted. Ultimately, Judge Thokozil Masipa sentenced Pistorius to 6 years in prison for Steenkamp's murder in July 2016.
On count 3, contravention of section 120, subsection 7, alternatively count 120, subsection 3A, and further alternatively section 120, subsection 3B of the Firearms Control Act, number 60 of 2000, the accused is found guilty of the second alternative, that is the contravention of section 123B. On count 4, contravention of section 90 of the Firearms Control Act, number 60 of 2000, the accused is found not guilty and discharged.
This sentence was later increased to 13 years and 5 months after an appeal by prosecutors who argued that the initial sentence was shockingly light. On June 4, 2014, in the Shirley Hills neighborhood of Macon, Georgia, 49-year-old Hank Baker was discovered naked in a woman's yard. The homeowner reported that Baker attempted to assault her, but she managed to escape and call the police. Upon arrival, officers found Baker still on the property and took him into custody. In April 2015, following a trial in Bibb County Superior Court, Baker was convicted of attempted rape and battery.
lack. He started lacking it when he told that absurd story about this lady attacking him. It didn't get any better when his blackout suddenly cleared up. Sold became exclusively for the purpose of telling that absurd story. He didn't say anything compared to what he could do. But on count one of his indictment, I found he gives it since he was 30 years in penitentiary. Do what? Do what, Mr. You want to hear count two, you want to do that after you leave? Count two, 12 months in the county jail, and run concurrent with 30 years that we gave you on count one. That's up to the Department of Corrections. If it were up to me, the answer would be no. But it's not up to me. So they'll get to decide that. And I'll let it run concurrent with whatever you get in Barrow County. So where I'm living, you'll need to make a difference by the time you get out of here. Y'all take the record for this.
This case underscores the importance of community vigilance and the swift response of law enforcement in apprehending individuals who pose a threat to public safety. In July 2015, just weeks after the Charleston church massacre, a group of people drove to a birthday party in Douglasville, Georgia, in trucks flying Confederate flags. The mother of the child, whose party it was, accused the group of threatening her family, claiming they walked onto her property and made racial threats. The people involved argued that the confrontation began because someone at the party threw an object at one of their trucks. But video evidence and testimonies led authorities to charge several individuals under Georgia's street gang terrorism law. During the trial, it was revealed that members of the group pointed weapons at the party attendees, including children, and repeatedly used racial slurs, including the N-word. A Douglas County judge determined this was a racially motivated crime and sentenced two of the individuals involved. Jose Ishmael Torres, 26, was sentenced to 20 years in prison with 13 years to serve for terroristic threats, gang activity, and other charges. Kayla Ray Norton, 25, was sentenced to 15 years in prison with 6 years to serve. She apologized in court, saying she deeply regretted her actions and claimed that her behavior that night did not represent who she truly was.
I do accept the responsibility for what I've done. I know I was in the wrong. But I want you all to know that that is not me. That is not me. That's not him. I would never walk up to you and say those words to you, and I'm so sorry that happened to you. I forgive you. I forgive all of you. I'm not a big spirit person. I do. I forgive you. And to your family, I'm sorry. It had to come to this fault. But please don't think that I have any hate or anger in my heart. I was too short for that. And I'm saying that I don't have time to have hate in my heart for anybody. And I do not really forgive.
Other members of the group pleaded guilty and were sentenced to 2 to 4 years in prison. Judge William McLean emphasized that their actions were not just a threat to one family, but to the entire community, as multiple people had called 911 in fear that night. He made it clear that the defendants needed to be held accountable for their actions. Anna Sorokin, known as Anna Delvey, is a Russian-born German con artist who, between 2013 and 2017, posed as a wealthy German heiress to infiltrate New York City's elite social and art scenes. She deceived individuals, banks, and hotels, amassing approximately $275,000 through fraudulent means. In 2019, Sorokin was convicted of multiple charges, including grand larceny and theft of services, resulting in a sentence of 4 to 12 years in prison. She was also fined $24,000 and ordered to pay restitution totaling $199,000. After serving nearly 4 years, she was released on parole in February 2021. Following her release, Sorokin was detained by U.S. Immigration and Customs Enforcement, ICE, for overstaying her visa. In October 2022, she was granted bail and has since been under house arrest in New York City, wearing an ankle monitor while contesting deportation.
She altered her personal identity documents. She repeatedly left such premeditation. It's an indication that there is a great risk that the defendant, once she is released from incarceration, that she will simply go out and attempt to perpetrate a similar scheme again. And then the court made to support the idea that she seemed to be basking in the press attention rather than thinking seriously about the crimes that she had committed and how they affected people. She had a friend of hers tweet who would be her preferred actress to play her in a movie version of her life. She was not reflecting on the harm that she had caused to the financial institutions and the businesses from whom she had stolen goods and services. The defendant's conduct, as was revealed during the trial, involved a great deal. The defendant repeatedly delayed these court proceedings because she was not happy with the clothing that was offered to her by the Department of Corrections. On numerous occasions, the people had to send their witnesses back home and have them come on different days because the defendant was unhappy with the clothing that she had on offer. And in fact, the only time during these proceedings when the defendant genuinely showed any sort of emotion when she was crying because she was upset about the clothing that she had received from the Department of Corrections.
I've had numerous conversations with Ms. Sorokin about the mistakes that she made and what led her to those mistakes. I've had conversations with her about her future and how the same skill set that allowed her to get this far in life can be used in a productive and positive way for her future.
Sorokin's story has garnered significant media attention, inspiring various adaptations, including the Netflix series Inventing Anna, where actress Julia Garner portrays her. In 2024, she participated in season 33 of Dancing with the Stars, performing with an ankle monitor due to her house arrest.
I apologize for the mistakes I made.
Sadly, I agree with people if Ms. Sorokin had spent half as much time working legitimately to raise money for a foundation that sounded like a good addition to New York, as she spent concocting phony bank statements, fake wire transfers, and non-existent financial advisors, she might have done quite well for herself. She's clearly smart and very creative. She was just a young woman following her dream, naive maybe. Therefore, the defendant is serving, all told, a minimum of 4 years incarceration, a maximum of 12 years incarceration, $198,956 $198,956.19 in restitution, and $24,000 in fines. It is so good.
Her casting sparked controversy, with critics questioning the platforming of a convicted fraudster. Despite her criminal past, Sorokin has ventured into the art world, selling artworks and hosting exhibitions. She continues to attract public interest, balancing her creative pursuits with ongoing legal challenges. In March 2012, Brevard County Sheriff's Deputy Barbara Pill was fatally injured during a traffic stop in Melbourne, Florida. The incident occurred after Deputy Pill stopped a vehicle linked to a theft at a local motel. Brandon Bradley, the driver, fired multiple times at Deputy Pill, resulting in her demise. His passenger, Andrea Kirchner, was also present during the incident. In 2014, Bradley was convicted of first-degree premeditated murder and sentenced to death, following a jury's 10-2 recommendation.
Bradley, as to count 1, you are judged guilty of the crime of first-degree murder for the unlawful of Deputy Barbara Pill. For this crime, the court sentences you to be put to death in the manner prescribed by law. As to count 2, you are judged guilty of the crime of robbery. For this crime, the court sentences you to serve a term of imprisonment in the Department of Corrections for the state of Florida for a term of 15 years. As to count 3, you are adjudged guilty of the crime of fleeing or attempting to elude a law enforcement officer, siren and lights activated, with high speed or reckless driving. For this crime, the court sentences you to a term of imprisonment in the Department of Corrections for the state of Florida for a term of 15 years. As to count 4, you are adjudged guilty of the crime of resisting officer with violence. For this crime, the court sentences you to serve a term of imprisonment of 5 years in the Department of Corrections for the state of Florida. These sentences are to run consecutive with each other. The defendant is entitled for credit for time served of 844 days as calculated by the clerk. You are advised that this judgment and sentence shall automatically be appealed to the Supreme Court of the state of Florida. Defense counsel is directed to perfect the appeal. The public defender is hereby appointed to represent you on appeal. Should you not have private counsel or are unable to afford private counsel, you are hereby remanded and without bail to the custody of the sheriffs of the Brevard County to be delivered for commitment to the Department of Corrections, where you will be confined until final execution of this judgment and sentence prescribed by law. Mr. Bradley, may God have mercy upon your soul. This court is now in recess.
However, subsequent changes in Florida's death penalty laws, which now require a unanimous jury recommendation for such sentences, led to the overturning of Bradley's death sentence. In 2021, honoring the wishes of Deputy Pill's family to avoid the trauma of a retrial, prosecutors agreed to a sentence of life in prison without the possibility of parole for Bradley. Andrea Kirchner, Bradley's accomplice, pleaded guilty to accessory after the fact of first-degree murder and other charges. She was sentenced to 12 years in prison for her role in the events leading to Deputy Pill's demise. Brandy Sue Jones, a 40-year-old woman from Montcalm County, Michigan, was sentenced to 12 to 30 years in prison for a hit-and-run incident in August that resulted in the demise of 14-year-old Jamison Lafferty and injured 2 other teenagers. She was convicted of 3 felony charges, including failure to stop at the scene of an accident resulting in death, and 2 counts of failure to stop at the scene of an accident resulting in impairment or injury. Her sentences will be served concurrently. The tragic crash occurred as the 3 boys were walking home after visiting their childhood babysitter. Jones, under the influence of meth and on parole for a previous meth conviction, struck them with her car. Jamison was fatally injured, while the other boys suffered serious injuries, including a broken pelvis and broken ankles. Jones fled the scene, later claiming she didn't realize what she had hit until she saw news reports the following day.
You know, this is a time for accountability. And this court was faced with a decision early on when I met with your attorney and Mr. Lowe in terms of fashioning an appropriate sentence that would hold you accountable, that would never ever begin to replace this felon, but would hopefully do justice to him and to his memory and all that he was to his loved ones. There's been a suggestion here that you have life without parole. And clearly that is not an option to this court in terms of the offense that you pled guilty to. And it was important to me when I met with counsel to afford the family some sense of assurance short of going through a trial, because that too is devastating and wreaks such an impact on families and communities. And so when I had met with counsel, and after I had an opportunity to hear from Mr. Belay and Mr. Nave, I had indicated that in the event that you were to enter a plea, that the court would cap your sentence at 3/4 of the maximum to give that assurance to the family and to you as well, so that you knew exactly what was going to happen. You know, there has been reference here that you should plead guilty, but yet from a legal perspective, it's clear to me that you were in such a sense of distress on the night that that occurred, and living your own pain under the influence of substances.
During sentencing, the court heard emotional statements from Jamison's family and loved ones. His parents, Justin and Allie Lafferty, spoke of their grief and the future milestones Jamison would never achieve. His grandfather and grandmother also shared their heartbreak and described the outpouring of love at his memorial service. During sentencing, the court heard emotional statements from Jamison's family and loved ones. His parents, Justin and Allie Lafferty, spoke of their grief and the future milestones Jamison would never achieve. His grandfather and grandmother also shared their heartbreak and described the outpouring of love at his memorial service.
That you do not have the proper recall that would be required for this court to be able to accept a guilty plea from you. Coming in here today, accepting responsibility and apologizing to the family, I think is the very next best thing that you could possibly do for this family, to give them hopefully some semblance of peace and the strength to continue to persevere each day without Jamison and Lafferty. His full name. So, Ms. Jones, it will be the sentence of this court on count 1 that in failing to stop at the scene of an accident when at fault, resulting in death as a habitual offender third, that it will be the sentence of this court that you serve 12 years to 15 years with the Michigan Department of Corrections without any credit for time that you've served in jail since your arrest in light of your parole status. On counts 2 and 3, which will be consecutive to concurrent to count 1, but also consecutive to your parole sentence, you will be required to serve 57 months to 10 years on each of those counts, counts 2 and count 3. You will be required to pay restitution in the event that the family submits any restitution requests that have not been received to date, but the court will leave that open to them. There is a crime victims assessment of $130, $550 in court costs, $2,000 in a fine, $400 in attorney fees, and $68 in state costs. As it relates to counts 2 and 3, there is an additional $68 for each count for a total of $136. And again, restitution will be reserved to Steve Lawrence and Emily Hatter, the parents of the other victims who have not spoken here today, but whom this court is very mindful of have been impacted by your actions forever as well.
Jones expressed regret in court, stating she wished she could trade places with Jamison. She also shared her own pain from losing a child to a substance overdose. Despite their immense grief, Jamison's parents and grandmother forgave Jones, expressing hope for healing. Prosecutors noted Jones's history of criminal behavior, including her parole status and past convictions for meth possession and driving without a license or insurance.
So, Ms. Jones, you do have, in light of the fact that you've entered a plea in this matter, you don't have an absolute right to appeal, but you do have the right to seek leave to appeal within 42 days from today's date. Mr. Relay just handed Mr. Nave that advice of appellate rights. If you would initial where he is directing you, and the legal file would reflect that he's been advised of your rights. So 144 months in terms of the clarification. That being 12 years. So in this matter, in closing, again, I wish the Lafferty family.
I'm sorry, the sentence, you said 12 and 13, correct?
12 to 15. I'm sorry, let me correct that, yes, 30 years in terms of the maximum. So what that means is that the minimum is the amount that you will be required to serve after you complete your parole sentence. And it will be interesting to see what the parole board does get that, in the sense that you are still in the midst of that sentence. So this sentence will not begin until such time as you are released on that parole sentence. So it will be up to a maximum of 30 years. So obviously your conduct and the choices that you make in prison, the people that you choose to align yourself with, will have a direct impact on how much of that 30 years you serve. So I wish for you that you choose to live your life differently, to do good things so that evil doesn't prevail here, and so that the light of this young life will carry on, and the memory of the good things that you do in his honor. Thank you. That concludes the proceedings.
The judge honored the family's request by not granting Jones credit for time served or early release for good behavior. The emotional courtroom was filled with family and friends wearing shirts and sweatshirts honoring Jameson and his friends. In December 2015, 24-year-old Kajavia Globe was reported missing by her family in Detroit, Michigan. Tragically, her body was discovered days later, concealed in a trash container behind a residence on Fielding Street. The investigation led authorities to her ex-boyfriend, Maxwell Brack, who was subsequently arrested and charged with her murder. In August 2016, Brack was convicted of second-degree murder. During the trial, evidence revealed that after taking Globe's life, Brack callously disposed of her body and used her ATM card, actions that highlighted his disregard for her. At his sentencing on September 27, 2016, emotional victim impact statements were delivered by Globe's family members. Her mother, LaShonda Globe, expressed profound grief and anger, describing how Brack had destroyed their family and taken something irreplaceable from them.
He took advantage, and he don't care. He ain't shown no remorse. He don't care. He killed my baby, and she was so dumb. She loved this monster. You done went to the bank on my baby money. You ain't know nothing about J. Alexander. Baby, she brought you into something. You took my baby from me, Max. And I have told you and Kajavia, leave each other alone. Because one day one of y'all could hurt each other. But you hurt her intentionally, but you didn't see her. But you knew she had groceries in her car. And then a seizure. My baby had a convulsion, Your Honor, while he was her. Because that honey, out of her 24 years, she never had a seizure. In 09, she was enjoying her senior prom, living the life. He was mad because he wasn't invited into that lifestyle. That's all that was. He was jealous. I told Kajavia, he's jealous of you. Ma, you just don't like him. I said, baby, he don't like you. And look where we at today. This man has destroyed my family. My daughter was finna go to the Navy August the 3rd. Her mind ain't even right. He just destroyed it. Do you understand? Don't care. He don't care. That was him at the bank. I said it from day one because he had on that mask. I didn't care because Lucy's phone was sitting right in his lap. A lot of stuff at the trial was not mentioned, and I am highly pissed off. I'm highly upset about that too. Some facts that I felt should have been brought out, and I thank you because you called it a couple of times. Well, I was like, I couldn't say it, but you felt it. Like, let's get serious with this. Because a lot of people got on that stand was a joke. They didn't bring nothing to the table for this. Because he would have got first degree. Do you understand? If it would have been ran right, he would have gotten first degree. Because Max know he did it. That's why he got some flyers and didn't pass them out. That's why I can't understand how the video of when my daughter met him. I saw that video. And the video, y'all talking about his demeanor. His demeanor. That video told his demeanor. That tape speaks for itself. Not them other young ladies. A demeanor after he was in there all discombobulated. Couldn't get himself together. Okay? Whether he known he was taped or not. Okay. So what? He know he had took Kajavia. And then she loved this man.
The presiding judge condemned Brack's actions and demeanor, particularly noting his inappropriate smiling during the proceedings. Citing his despicable, insensitive, and selfish behavior, the judge sentenced Brack to 70 to 100 years in prison, explicitly stating that the final 10 years were added as a consequence for his lack of remorse. This sentence exceeded the typical guidelines, reflecting the severity of the crime and Brack's apparent indifference. In a courtroom scene that felt more like a movie than real life, Alan McCarthy Jr., a foul-mouthed man from Florida, was sentenced to prison for threatening to take a judge's life. His outbursts and rude behavior during the trial led to an extra 10 days in jail, and at one point, the judge almost had to tape his mouth shut to control him. Alan McCarthy Jr., 36, from Milton, Florida, was convicted in August for threatening the life of Circuit Judge Stasia Warren after a ruling in a child custody case. His threats didn't end there. He also targeted a prosecutor's unborn child.
I'm going to tell you to be quiet, and you need to be quiet. There's not going to be a second time. If there's a second time, I'm going to duct tape.
The courtroom was tense from the beginning. McCarthy exploded with curses as Judge Foxman read his sentence.
You're a liar. Thank you very much, sir.
McCarthy screamed, leading Foxman to have him removed from the courtroom. Even after being taken out, his voice could still be heard echoing through the courthouse as he kept shouting curses and racial slurs from a different room, where he watched the trial through one-way glass.
You threatened my life.
McCarthy's disruptions started well before his sentencing. His outbursts were so constant that Judge Foxman had warned he would tape McCarthy's mouth shut if it continued. At one point, McCarthy rudely made an inappropriate suggestion to the judge, which Foxman politely refused.
You want to take all my paperwork from me, lock me in a cell, naked all night?
Even after being moved to a separate room during the trial, McCarthy's behavior didn't get any better. He insulted his public defender, Ryan Belong, refused to wear proper courtroom clothes, and kept shouting offensive comments.
Brought your dress today, you little. You want to take my kids from me and act like that? You wearing that, bitch.
The jury, made up of 3 women and 3 men, took only 30 minutes to convict McCarthy on several charges, including threatening extortion and corruption of a public official. This wasn't a surprise, as his threats went beyond Judge Warren. He also insulted dispatchers during phone calls. McCarthy, who was watching the verdict from his separate space, stayed unusually quiet as the guilty verdicts were read.
No, you
Back room.
suck. No, I'm not resisting. I'm not resisting.
McCarthy's threats came from his anger over losing custody of his children. He argued that his threats were just words and not meant to be taken seriously. However, Assistant State Attorney Ashley Twilliger pointed out the seriousness of McCarthy's actions, noting that Judge Warren was genuinely afraid for her safety. McCarthy's children had been living in Texas for years, and he hadn't seen them since 2020. Throughout the trial, McCarthy's behavior was disruptive. He kept interrupting the proceedings, refused to cooperate with his defense, and even claimed his rights were being violated because he was kept in a separate room. His actions led to extra security, including an electric belt under his jumpsuit that could stun him if necessary. During the trial, McCarthy made disturbing threats in recorded calls, promising to take Judge Warren's life in the street. Warren testified about the fear she felt when she learned of McCarthy's threats. Despite McCarthy's constant interruptions, the courtroom remained calm.
All right, raise your right hand. I'm going to swear you in.
I'm not under oath.
That's your bad finger. I didn't appreciate it.
In the end, despite his disruptive behavior, McCarthy was sentenced to 20 years in prison. In a tense courtroom scene, 22-year-old Jamao Hayden was sentenced to 10 years in prison as part of a plea deal for the 2019 incident that led to the tragic loss of 19-year-old Christian Gwynn. Gwynn lost his life in the Shawnee neighborhood just days before Christmas while walking home. Hayden was not arrested until 2 years later, and his sentencing brought strong reactions from Gwynn's grieving family. During the hearing, Gwynn's father confronted Hayden, accusing him of being a coward and a disappointment. When Hayden appeared to smirk, tensions boiled over and the courtroom erupted. Security had to intervene, and Gwynn's father was escorted out.
You kicked my
my son, Christian Gwynn. You took a son away from his father and a brother away from his siblings, and for that you will never be forgiven. You think you tough, but for real, you a coward and you a disappointment to your family and people out here in the community.
Is it funny, bro?
Yeah.
Is it funny?
Sir, you're...
Is it funny? You want to crack a smile, man?
Sir,
You want to crack a smile,
I'm
bro?
gonna have to ask you to leave.
I wish the judge would give you forever.
Don't laugh at man.
I wish you would get forever. Away my son. Don't say nothing. How you won't get too? Don't say nothing because they're gonna kick you out. Say your word.
Afterward, Gwen's mother and sister continued their victim impact statements, expressing their grief and hoping that Hayden's time in prison would be difficult.
Killed a great man, and for that, I hope forever your days are hard and you never see the sun again. I hope he hurt you. I hope you rotten.
Judge acknowledged the family's pain, emphasizing that no sentence could truly equate to the value of their loved one's life.
As torn apart as you are, I would like you to walk out of here at least knowing that there is nobody here who thinks your loved one's life was only worth X number of years. There is no equivalent. So I appreciate what you said.
Due to the seriousness of the crime, Hayden was not eligible for probation. In January 2010, 16-year-old Daniel Kovarbese fatally stabbed 55-year-old Dwayne Hurley in North Ridgeville, Ohio. Kovarbese alleged that Hurley had been abusing him for over 3 years, following a typical grooming process that began when Kovarbese was 12. On the day of the incident, Kovarbese claimed he acted in self-defense after Hurley attempted to initiate sexual contact. In April 2010, Lorain County Common Pleas Judge James Burge found Kovarbese guilty of voluntary manslaughter and aggravated assault.
The Daniel's story didn't change, it varied. It went from self-defense to no defense at all. But I don't find that change in the account due to his calculating personality or intellect. The psychological report, mental status report that was conducted before this matter was bound over to the adult system indicated that although not mentally ill, Daniel was very low functioning at the time this offense was committed. I hope that the conclusion is that the low functioning was due to a lack of interest rather than a lack of intellect. Or it will be the judgment of law and sentence of the court that this defendant serve a community control sanction with a term of 5 years, which will expire on August 12, 2015. For completing this community control sanction, the defendant will receive a high school education and a driver's license. He will be under intensive supervision for a period of 5 years. He will remain incarcerated until admitted to a program of rehabilitation selected by the court.
One of these conditions required that he remain in custody until a suitable juvenile rehabilitation facility could be found. Due to the violent nature of the crime, placement in such a facility proved challenging. Consequently, Kovarbese spent approximately 16 months in the Lorain County Jail before being released under house arrest in May 2011, pending placement in a treatment program. The case drew significant media attention, highlighting issues of abuse, self-defense, and the complexities of sentencing in cases involving juvenile offenders. Kovarbese and his family appeared on The Oprah Winfrey Show to discuss the abuse and its aftermath, aiming to raise awareness about the grooming process and the importance of reporting sexual abuse. Thank you so much for watching. Don't forget to subscribe and hit the notification bell so you can stay updated with our latest videos.